New York cites historical bigoted gun bans to defend its own laws in court. Plus, Alan Gottlieb of the Second Amendment Foundation explains his approach to the post-Bruen landscape. That and more in this episode of the Weekly Reload Podcast.
I made the devil run. I gave him poison just for fun.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free Friday newsletter. It goes out every Friday. You'll get the latest and greatest gun news in the country. You can keep up to date with just that one newsletter each week to have a better understanding of what's going on with guns in America. And if you want to go a bit deeper, you can also check out one of our membership options. Become a member. That's the way we're able to operate. Our members are the only source of income we have at The Reload, and that makes us responsible to them and no one else. But if you want to help support what we're doing, you want to help continue to publish sober, serious analysis of firearms news, that's the best way you can do it. You'll get exclusive access to hundreds of pieces of reporting and analysis that you can't get anywhere else. You'll get this podcast a day early, and you'll have the opportunity to appear on the show, which we have a member segment this week. So make sure you stay tuned to the end for that. But, we've recently talked a great deal about the Supreme Court's Bruen opinion, its decision, this landmark gun carry decision that the court held, gave down earlier this year. And we've talked to Charles Cooke from National Review. We've talked to Andrew Willinger of the Duke Firearms Law Center, got their perspectives on what this all means for the future of gun litigation in America. But today, we're going to talk to somebody who is actively involved in that kind of litigation. We have Alan Gottlieb, who's the founder of the Second Amendment Foundation, which is involved in many suits across the country already. And welcome to the show, Alan. Thanks for coming on.
My pleasure. It's really great to be with you and your listeners. Thank you.
Absolutely. And can you just tell people a little bit about yourself and a little bit more about the Second Amendment Foundation?
Well, I guess I've been involved in the gun rights battle since about 1972 on a full-time basis. So I have a lot of historical, view of this whole thing. And when I got involved in it, I founded the Second Amendment Foundation back in 1974. And one of our purposes was to eventually get a case to the United States Supreme Court. And, now we've had three big ones at the Supreme Court in total. I guess when we first started, it was a pipe dream. But we did it, but we had to set the ground rules and the framework to ever get a case there. And back in 1972, there really were no cases that you could really point to nationally that supported Second Amendment rights as an individual right. In fact, the only case, Stephen, that was out there was an Oregon case based on the Oregon State Constitution supporting the right to keep and bear arms. And it didn't even involve a gun. It involved a knife. And it was a criminal case that they prosecuted a person for having a knife. And the state Supreme Court ruled that, in fact, that knife was covered by the Oregon Constitution for the right to keep and bear arms. And that's really all that existed back there in 1972. And so we started holding legal.
But things have.
Yeah, go ahead.
Things have changed quite a lot since then, right?
Yeah. So we started holding some legal scholars conferences, bringing pro-gun attorneys and legal scholars together to determine what we had to do to ever be able to build a framework or a foundation to ever get a case to the United States Supreme Court. And it started a lot with like law review articles and, serious historical journals and popular culture publications. And we started getting articles written in place to build a framework for this. And then one of our legal scholars conferences, we invited a lot of people on the other side too, because we wanted them trying to pick apart where we were going and what our weaknesses were. And they didn't realize that what it was for. And they helped us out a lot, telling us where our weaknesses were. One of the things that came out of one of these conferences, what was really important, was the idea of, you couldn't challenge all these laws if you didn't have the Second Amendment incorporated through the 14th Amendment, making it applicable to all 50 states. And we brought in the dean of the University of Florida Law School, who went over a lot of stuff with us with incorporation. And pretty much we had to start out a suit that had to be against the federal government or a federal enclave to determine the individual right before we could ever even get a case to go to incorporate the Second Amendment through the 14th. So it started again, as most of your people probably know, with the Heller decision in Washington, D.C., because that was not a state and we could win. And then that day we won that suit, the same day we filed the McDonald versus Chicago suit to knock out Chicago's gun ban and incorporate the Second Amendment through the 14th, which then made all these other cases possible, including the Bruen case that went to the Supreme Court, challenging New York.
Yes, so there's quite a lot of history there. And you guys are involved all along the way. And of course, you're still involved in gun litigation after Bruen. You have, how many cases do you think you have going right now? Or, rough estimate.
We have approximately 40 cases going on Second Amendment rights across the country right now. And that's about the number we had pre-Bruen. And some of those we've already sort of won or taken off the board. And now we've got new cases coming up on the board. So we're staying around that 40 number, which is unbelievably amazing. If we were a major national law firm and had 40 active court cases going on at one time that were actually being litigated, that would be an awful lot to keep track of. And we're just a nonprofit organization that has 40 cases going on. So it's quite a challenge.
Yes, I imagine. And so what are, I just give us straight away your reaction to Bruen. What do you think the impact of that holding is going to be on gun litigation from this point out?
Well, it's a major impact, not just on gun litigation, but on gun legislation as well, because we're having a reaction from the other side passing new laws. But basically, the important thing about not only overturning the New York, so-called ban on carry, which is basically what it was, it got rid of the so-called two-tier system on how federal courts determine Second Amendment rights. And basically said that you have to go with what the text and history of the Constitution is to determine your verdicts in defining Second Amendment litigation. And this system where it allows governments to come in, states to come in and argue, well, it doesn't matter what the Constitution says. We have to pass these laws and they have to be upheld by the courts because we have a crime crisis in our country. It's we have all these crimes being committed and we have to stop it. This is the only way we can stop it. Well, now they can't argue social benefits or whatever it might be. They've got to go look at what the Constitution actually says and why it says it. And that's really, really important because a lot of times they trip us up with the anti-gun judges. Like it doesn't matter what the Constitution says. There's a need to ban guns. And so, that overrules, what the Second Amendment says. That's no longer the case. And that's very important for us.
Yeah, certainly. Although, the reaction thus far in places like California and New York have been pretty fascinating to watch because they're certainly not passing gun restrictions with that framework in mind that you just mentioned there, right?
No, I think they're doing this really emotionally. And what's happening is, let me back it up just a hair. You have some places like, say, Maryland, that, by order of the governor have changed how they can give out their permits. You've got even in California, the Attorney General now said, they pretty much have to be shall issue, not discretionary the way they were, based on the California law. And you've got some other places that have, are basically talking about, they haven't changed the laws necessarily, but they talk about they won't be enforced the same way they were. So we've already seen some motion from the legal side of the anti-gun states where some of them realize they're in trouble and they don't want to have to relitigate it. But then you've got, like you mentioned, New York, California, where they've passed a whole bunch of new laws as well. Particularly California, which is, I think it's now something like 9 laws they've passed roughly that, to attack gun rights, with more on the drawing board, some sitting on the governor's desk to sign into law.
Some which you've already challenged as well. We'll get to that later. But
yeah. So there's a whole lot to challenge. I view this whole thing now in post-Bruen, that I'm looking at things in like 3 or 4 tiers of what we're going to be looking at. One, because of Bruen, we have, the key states we're looking at are like New York, Maryland, Massachusetts, California, New Jersey, and Hawaii, which had a lot of restrictive laws on the books. And then California, of course, with all their new proposed legislation, Again, even though the Attorney General gave out a letter to law enforcement that they can't enforce some of the laws the way they're enforcing them. And even the New Jersey Attorney General did the same thing, that they can't enforce some of the laws the way they were enforcing them. And in New York, they've sort of said that on the legal side of it, to the law enforcement, but then they've, passing all kinds of new legislation and redefining things in New York. Our two biggest problems right now really are New York, California, and New Jersey, just a step behind them. That's my the tier one area.
Mm-hmm.
Well, that's only part of tier one, I guess, because New York, as an example, they're trying to redefine sensitive places, which is going to be forthcoming litigation on the tier one side, like making Times Square and blocks around it, a gun-free zone, so to speak, where you can't carry a firearm even if you're licensed to do so. So now we have to give you the license, but we're saying you can't carry the gun in these places. And of course, what they'd like to do is make the whole city of New York a sensitive place and make the permit system like non-existent anyway.
And they've also flipped the usual standard for private property on its head, because in every other state, basically, you have to post if you don't want somebody to carry into your place of business. You have to post a sign that says no guns, whereas New York is now is trying to flip it the opposite way and saying you can't carry unless the store has posted that they allow it, which is a monumental shift that would have a pretty massive impact on where people can actually legally carry guns.
Yeah,
right?
And of course,
that
puts the burden on the store owner, shopkeeper to post it, and if they don't get around to it, you just don't get to carry your firearm. It's almost like a negative checkoff system, and historically that doesn't hold up very well in the courts. So I'm not sure they're going to get away with that. We also have what we're looking at in our tier one is non-resident carry. A lot of states still, even complying with Bruen, so to speak, with their current laws, don't want non-residents to be allowed to carry. So we're looking at a lot of non-resident suits now, because your right to carry a firearm shouldn't stop at your state border. And the Bruen decision, I think, helps us out a whole lot in those areas as well. We're also looking at abusive licensing systems, some that existed before and some that are going to be coming in place of some of these new laws. But, putting all kinds of requirements, making it next to impossible to go through the system, excessive fees, excessive time constraints, discrimination because of your political views. I mean, we're now looking at places like New York. They're talking about how they want to look at your Facebook post before they say you have good character to be able to, apply for the permit and get it. And we're looking at that happening federally as well, with a lot of members of Congress pushing in that direction. So there's a whole lot of areas there as well. And then we're looking at disclosure of privacy rights, where a lot of the states are now looking at, well, okay, you can have the permit, but we're going to make it public so that every newspaper can put your name in there saying you own and carry a firearm, so we can bring pressure against you, things of that nature. And then, of course, the two big ones are, so-called semi-automatic firearms that they like to call assault weapons, so restrictions on those, and large capacity magazines. So we're in court on those right now. When we had filed pre-Bruen, knowing we were going to win Bruen, we really felt that was a winning case, with challenging Maryland's assault weapon ban, which then, of course, got sort of overturned or remanded back down for retrial, by the U.S. Supreme Court as part of their Bruen decision, or right after the decision.
Right.
And Maryland now, we're looking to overturn the Maryland semi-automatic ban, which will then affect a number of other states as well. So we're kind of excited in those areas. And then, of course, we have a lot of magazine ban litigation that was filed pre-Bruen as well, knowing that we were going to win. We have, like here in Washington State, my home state, which banned magazines that hold more than 10 rounds. The sale, you keep the ones you had, but no new sale or manufacture of those. They thought that Washington State thought that was going to be a slam dunk win, and then post-Bruen, now they're backtracking about how much harder it's going to be for them to win the case, and they're whining and crying a whole lot. So those are sort of my tier one category of cases, and then we're looking.
And then, so how do you decide what's in tier one and what's in tier two?
Well, I think by the tier one cases are the ones we think we have the better chances of winning no matter what, and the tier two ones are like a hair below those. So we're sort of doing it, where we think we can actually accomplish the mission and win for Second Amendment rights. Our slogan has been winning Second Amendment rights one lawsuit at a time. We're kind of moving in that direction, and Bruen just makes it easier for us.
And so, what are just one or two examples of tier two?
Well, tier two, excessive training regulations, where in order to get this permit, they're going to make you, go through unbelievable amounts of training. And look, you have some places now, like New York City could be an example, where they're going to make you go through a lot of training, but there aren't a whole lot of gun ranges. And the training, you're looking at, 15 hours or so, and on range training, there aren't enough ranges in New York City to be able to accommodate that. So by putting a lot of range training in and knowing there's no place to get the training, they're able to thwart your Second Amendment rights. We had this situation in Chicago when we won the McDonald suit at the Supreme Court and knocked out the gun ban in Chicago. The city of Chicago said you had to have range training to get the permit to own a firearm in your own home, except they banned gun ranges in Chicago. And so we filed the Ezell 1, I call it, case, and knocked out the ban on ranges in Chicago. And so then they came back and Chicago passed, okay, you can have ranges, but the ranges have to be set up certain ways and made it in a way that was impossible to build out a range anyway. So we filed again in Ezell 2, and we knocked out that in Chicago as well. So this is kind of what we're looking at. The anti-gunners aren't going to give up. They're going to keep, pushing any way they can to make it hard and restrict gun rights. And so we're looking at those kind of cases. And we've already had success before, but I think we're going to win on those. And then the 18 to 20-year-old, where they don't want to give permits to people to either own or carry a firearm if you're a young adult. We have a lot of those cases pre-filed, pre-Bruen already, and we're looking at filing some more of those. And then we're looking at, a lot of states where they can let you carry concealed, but they won't let you carry opened at all. We now think there's an opening there that at least, they'd have to let you have a permit to carry openly. They can't just ban it either. Storage laws. A lot of places have passed before. We've already won on some of these cases, but we're seeing a pushback against this. So, okay, you can now own this gun, but you have to store it, carry it in certain ways that make it useless. And we're looking at that. We're looking at, again, range restrictions by various townships and cities where, okay, you can have gun ranges, but, they're non-usable, so to speak, or we make it next to impossible to build them. And then the banning on self-made firearms. It's been a long American tradition that you can make your own firearm in your own home. And we're getting an awful lot of pushback now post-Bruen in that area where more and more places are passing laws saying you can't, make your own firearm. And we're also seeing what they call anti-arsenal laws, where, you can only have so much ammunition or own only so many guns. And we're going to limit the amount of guns or ammunition you can have. And, as a result, that's our feeling of infringement of Second Amendment rights. And it's tier 2. There's this new ground to cover, but Bruen, again, helps us out that way as well. And then we got some tier 3 stuff, too, dealing with the FFLs, licensing of FFLs and how FFLs get treated. We're looking at just regulation of self-made firearms where they'll let you have it, but they're regulated in crazy ways. The handgun rosters, where a lot of handguns can't be sold in some states. We've had some suits in the past. We've both, that are still being litigated and some we've lost, which now I think come back. We're at more power under Bruen to bring those cases back. Penalizing firearms owners to be able to get information from the government on how they're regulating your guns or their behind the scenes anti-gun activities. They're trying to protect that so we can't sue to get that kind of information. And likewise, again, trying to make a lot of gun owner information public to the public so that, your privacy rights are really violated. And there's red flag laws is another area in our tier 3, which don't provide due process in their procedures. So those are our tier 3s. And I'm looking at some tier 4 stuff coming up now. That's new stuff that we haven't even thought of that the other side's coming up with. It's all new laws to infringe on Second Amendment rights. And so,
like what?
Well, like we had in California just now, when we just filed suit against that one. So it was tier 4, but we've already filed it, where any advertising or any mention of guns that might entice minors to be interested in firearms is now illegal, and you can go to jail or be fined for it, which kills all youth sports shooting, safety training, and it doesn't allow, like the Second Amendment Foundation, to even talk about gun rights to young adults because they might want to then own a firearm. And so we're really upset about that. And likewise, that particular law, while it bans the firearms industry from, putting out information that reaches minors. It doesn't do that to the anti-gun people. So they can put out everything about how guns are evil and kids should never own a gun when they grow up. That's okay in California. But to advocate that, you should have the right to own a gun, that's another story.
Right. Yeah. We just did a profile of one of the youth shooters, Lola Fitzgerald, who's affected by that law because of the sort of what appear to be maybe unintended consequences. Depends on who you ask in California, whether they intended for this to shut down youth shooting sports there or not. Certainly the governor argues that that's too broad a reading of the bill.
Some inside baseball for you in California. The Attorney General's office, the Justice Department of California, recognizes they have some problems with that law. And so they've reached out to our attorneys to say that, look, we're willing to amend it a little bit. So because we didn't really, it wasn't our intent it wasn't the legislature's intent to not allow safety training or this or that. So we want to amend part of it. And so if we amend it, will you drop your suit? But it still doesn't take away 90% of what's there that shouldn't be there anyway. So we told them, no, we're not amending our suit. You're going to have to litigate it. You wrote it this way. It's anti-Second Amendment rights. It's anti-First Amendment rights. And we're staying in court with this.
Interesting. That is interesting. I mean, I know CNN's Jake Tapper had reported that one of his sources close to the governor said that they were planning to amend the law legislatively. We haven't seen anything publicly about that yet. It's interesting that the Attorney General's office has apparently reached out to you guys along the same lines. But yeah, I would imagine that even if they put in some sort of exception for youth shooting sports to continue to operate, leagues to continue to operate, that you guys wouldn't necessarily be satisfied with leaving the rest of it in place. Right.
They've showed us their proposed language, which solves a little bit of the problem, but not 90% of the problem. But the thing is, they're admitting, the AG's office privately admitted to us, they got some problems and they need to fix something.
Yeah, well, I think that much is probably obvious to nearly anyone who doesn't just want to ban all guns. Because, I mean, skeet shooting is an Olympic sport, as the story that we wrote references, where we're actually the top American, one of the top American athletes of all time is Kim Rhode, who won 6 consecutive medals, or she medaled in 6 consecutive games, which is
she's won a lot more medals than that, but yes.
Yeah, she's won 6 medals, but she's won them in 6. She won 3 golds, 2 silvers or 2 bronzes and a silver, but she won them over the course of 6 games, which is an incredible feat.
Incredible strength.
Obviously, most athletes only participate in maybe 3, if they're lucky. Games that they don't, because the games are obviously 4 years apart from each other. So it's not usual to have that kind of longevity.
And if you don't start training at a young age, you're never gonna get to that kind of a peak. And right. California law really knocks a lot of that out right now.
Yes, and that's the problem for somebody like 16-year-old Lola Fitzgerald, who wants to be like Kim Rhode, and who has won a number of titles in California and elsewhere, but is now effectively cut off from her sport altogether because of this law. But yeah, so you guys are obviously challenging that alongside a couple of other gun rights groups in the state, and it is interesting to see that as part of the reaction to Bruen. Like you said, I mean, so you suspect, honestly, I would suspect that a lot of these very broad laws that they've passed in the wake of Bruen are not going to survive scrutiny. But I think that idea relies on this assumption that the Supreme Court is going to step in these cases if, say, the Ninth Circuit finds a way to uphold this youth advertising ban, for instance, or the bounty law that they've passed, or any number of the new restrictions on gun carry that have been passed in California. The Supreme Court's going to have to actually do something for that to matter, right?
Well, if it gets that far, yeah. I think.
Well, do you expect? I guess one interesting thing is, for a long time, we've expected that lower courts like the Ninth Circuit are going to find ways to uphold these laws. Do you think that still should be the expectation after Bruen, or what do you think there?
Well, no doubt, in some cases, the Ninth Circuit is not going to become gun friendly, and they're going to try to, pardon the pun, stick to their guns or stick to their anti-guns. But in a lot of these cases, the Ninth Circuit has been put on notice. And I think a lot of these cases now, the Ninth Circuit's going to have a harder time figuring out ways to get around the Supreme Court, like they were able to do, after Heller. Now it's going to be a different ball game. So do I expect to see some pushback there? Yeah, but they're not going to be on as good a ground as they were, and they know it, and they don't really want to be constantly overturned by the Supreme Court either. So it's going to be interesting to see. The battle is still going to rage in the courts. But I think we're in a much, much better position to win these. And you're going to get other circuits that are going to be totally ruling in our favor. And so the circuit splits are going to be there. And the Ninth Circuit knows that as well. So when you have other circuits ruling on these same kind of cases, because we've planted these kind of cases all across the country in various circuits, when you get other circuits ruling in our favor and then the Ninth Circuit tries to rule against us, it puts them in a little, worse light, so to speak. So we're on the offensive now, and the other side knows it.
Interesting. So one part I want to hear from you. One thing I'm interested in, and one thing that I've talked with some of the other people about, but the weaknesses of the Bruen standard. Like what do you think they are? I mean, certainly we've seen arguments that it all really depends on how far out you take this view of historical analog, right?
Well, obviously,
how closely do they have to be related before they're constitutional? I guess. Well,
obviously, our opponents now are going to try to distort the historical, standards, because that's all they can really argue now, and so they're going to have to, try to find ways to do that. They're on much weaker ground than they were before, and the Supreme Court, in Heller and McDonald and now in Bruen, pretty much talk about a lot of the historical standards, and so I'm not so concerned that we're going to lose on that. But the other side's going to surely try to manipulate it. There's no doubt about it. And the other thing that I think they're going to try to manipulate a whole lot is that obviously both in the Heller decision and the Bruen decision, referenced as well, that, there are some laws in sensitive places that they can pass to restrict carrying of firearms in sensitive places. Mm-hmm. And so they're going to try again, define the whole country as a sensitive place. And when they try to go overreach on that, I think we're going to be, going to be in good shape to win again. But there are some sensitive places that you're not going to be able to carry firearms in, and that's been the case before. And I think we're not going to get to overturn that in Bruen. Bruen didn't go that far in that area. But again, it's a monumental win for us, period. And the other side knows it. And, they're freaking out over it, quite frankly. But the more they freak out over it, the more they try to pass bad laws that don't have pass constitutional muster and don't make sense. And I feel we're getting more and more in the driver's seat with this every day. And so what we started back in 1972 with the Second Amendment Foundation and these legal scholars conferences and getting things published in law review articles, et cetera, has really paid off in spades, but it's taken a significant number of decades to get to where we are.
Yeah, that's certainly true. But so you don't look at something like, for instance, an assault weapons ban case. It seems clear that they're probably going to argue that, because there's historical tradition of regulating dangerous and unusual firearms, that applies to, AR-15s and AK-47s. You don't think that's, or the sensitive places, that we can extend these sensitive places to Times Square because Times Square has these unique set of circumstances that make it, different from your regular public area. You're not concerned that those are going to hold up in court, those sorts of arguments?
Well, on the banning of semi-automatic so-called assault weapons, I think we're going to win. The same thing on magazine capacity. I think we're going to win because those things aren't unusual and they're not overly dangerous. They can't win on that. And making those particular arguments again isn't going to hold up very well because historically, that doesn't make any. It really doesn't make any sense historically, and again, bringing in that something is dangerous or whatever isn't going to sell anymore because that Supreme Court said you got to look at the history and text of the Second Amendment, and that's what's going to that's the tripping point for them, and that's where they're going to fall on their faces.
Okay, so you're not as concerned about.
They will argue it. There's no doubt
Mhm.
about it. But I don't think they're going to win on it. If they
Right.
try to say something like, at certain times because of certain activities, carrying guns in Times Square may not be okay. Like maybe say like New Year's Eve itself. But to say, 24/7, every day of the year, you can't carry a gun, not just in Times Square, but with an X number of block radius around it, that isn't going to work.
Okay, so you're not as concerned about those sorts of arguments, even though you do expect them to be made in court. What is
Yeah.
it that you're concerned about then? Maybe legal minimization, where they try to rule that for instance, this law is unconstitutional as applied, but not make a determination on the constitutionality of the law overall. These sorts of things. Like, there's other ways that you can delay at least
Oh, yeah.
certain decisions. Are you concerned about those sorts of tactics?
Well, I think we're going to see things like, some anti-gun judges in the lower courts, timelines to hear your case. They're going to stretch things out, so it takes years to get your case heard.
Mhm.
There are all kinds of things the other side's going to do because they're evil. I mean, and they're going to misuse the system any chance they get to do it. But I feel really good about holding them accountable for it, and eventually, over time, day by day, instead of them chipping away at our rights, we're going to put the rights back together again.
And you think they're evil, not just misguided, or have a different opinion than you?
I think in this case, things are so polarized that it's not so much misguided. I think it's more evil, especially when you get politicians and people, even lawyers and judges talking about how well, we know this doesn't solve the problem, but we don't care. When they admit that, at that point they're evil.
Interesting. I mean, that's obviously very, very harsh take on it, but so. What do you think the ultimate outcome is going to be in this post-Bruen landscape? You seem very confident that you're going to have a lot of success here with these cases, and that there isn't really a lot of counter argument that's going to succeed in court here.
Yeah, I'm confident over time. There's going to be a setback here, a setback there. Going to have to then appeal something. And eventually, like you referenced earlier, something might have to go back to the U.S. Supreme Court where they're going to have to, make another decision in our favor. But I feel good about it. I wish things would happen faster. The legal system is slow. The other side passes a law that infringes on our rights, and they sign it into law and it's there in a day, so to speak. But you challenge it in court, it takes years. So my biggest frustration is how much time it's going to take to fully restore Second Amendment rights in the United States. But we're moving in the right direction every day, and that makes me feel good.
Okay. And so can you just give me which of the cases, talk a little bit more about that timeline? What do you think we're likely to see come to fruition first? Like for instance, these 4 cases that got remanded, which of those do you expect to actually have tangible results in the fastest? There's an assault weapons ban case in Maryland that you referenced. There was a gun carry case out of Hawaii. There's one out of California, right? Where are these? What should people expect to see next, like the next big development in gun litigation?
Well, I think anything in the Ninth Circuit, which covers California and Hawaii, is going to move slowly. So I'm not so sure how quickly those are going to get resolved. And I'm saying that because even if we win at the trial court level or at the appeals court level, you still have the possibilities of en banc in the Ninth Circuit. And so I think things in the Ninth Circuit are going to until it's fully resolved in the Ninth Circuit, it's going to take the longest probably. But the Maryland assault and ban case, I think, is going to move pretty quickly at this point. It's already back in the trial court and moving forward already. And so I feel good about that. And we got sent back to the trial court with pretty good instructions from the appeals court. So I feel that one's going to move fairly quickly. But things in California and New York are going to tend to move slower. In other states, they'll move faster. But we're definitely moving, and we're moving in the right direction. So it's hard to predict. If you look at the Heller case, I think that took, 6-7 years or something to get to the Supreme Court and get that ruling. And the McDonald case moved a lot quicker. I think that may have been 2.5 or 3 years to get it fully done. But these cases take a long time, and a lot of us gun rights activists get impatient, and we want our rights restored immediately. And unfortunately, that's the frustration we have. And of course, when these battles drag out, they cost us more money, and it's raising dollars to do it. We don't have the billionaires like the other side has, the Michael Bloomberg's, and the George Soros's, to help support it. So we have to raise our dollars in $10, $15 increments, so to speak, and it takes a lot more time to do it. So the other side's going to try to drag it out, especially when they know that they're on the losing side of things. They'd probably like to drag it out until maybe the Supreme Court changes its makeup, and they can get more anti-gun judges on the Supreme Court. Until that happens, I think they're going to try and drag things out.
Yeah, I mean, that seems like a logical approach, given what you've talked about here, that a lot of these states are likely to take. But I mean, how long do you think the court will wait until it takes another gun case? I mean, it feels like that's a really big question to me. I mean, obviously, you seem very confident in the outcome at the lower courts is going to be different this time around after Bruen, but I mean, I would still feel like the Supreme Court actually stepping in is going to be necessary at some point. Do you think it's going to take 14 years for them to issue another, significant update to Second Amendment jurisprudence?
I don't think it's going to take that long. We have several judges on the Supreme Court that at this point want to hear Second Amendment cases. So we have people in the court, pushing for it. Again, you need 4 justices to hear a case, and you need 5 to win it. So it's a matter of getting 4 justices to hear it. Right now, I think we have 4 justices that would be willing to hear a number of gun rights cases. So it's a matter of getting them through the court system and getting one there. And of course, you have to get one there that they feel comfortable with. And I think, quite frankly, like the Maryland assault ban would be one they'd feel comfortable with, because it's a very strict ban on how they define what assault weapons are. And it doesn't make any sense. I think a case like that, the court would take. I think, something even at this juncture on the 18 to 20-year-old young adult owning firearms, at this point, that's something the court would probably be interested in taking. And then, we've got other cases that I think we're going to win on that aren't even have to get to the Supreme Court. We just filed, one in California on their gun show ban on public property. And we already won a case in California federal court on that against the Del Mar Fairgrounds in San Diego. And they were so upset that we won that case. That what happened is they went legislative-wise and passed law statewide in California that basically, and I think they got around it being cute, but by too far by half. But they banned it, so to speak, on any public property anywhere in the state of California. And what they did was, instead of actually banning gun shows directly, they just banned the gun sale of any guns or ammunition. So you really can't have a gun show because there's no way that anybody's going to come to it if you can't buy or sell guns, which is obviously, a legal thing to do. And so that they're being cute. They think they got around it because they didn't really ban the show itself. They just banned all the activity that takes place at the gun show.
Yes, I imagine you'll be facing a lot of those sort of derivative restriction attempts in the future. We just filed suit against
the state of California and Orange County on that one, who passed an ordinance banning it in Orange County. And the 2 other counties in California that have also similarly passed laws like that. So we'll be filing 2 other federal lawsuits in 2 other jurisdictions in the state of California very shortly as well.
Well, we'll be keeping on top of those suits and your other suits because you guys are very prolific, as we described here on this episode. We certainly have a lot of cases going. A lot of them end up being quite important. So we will most certainly keep following them. And we appreciate you coming on. Where can people find out more about the Second Amendment Foundation if they want to?
Easiest places on the internet, saf.org, samalphafrank.org.
All right, wonderful. Well, we'll have to have you on again in the future to give us an update on how some of these cases actually played out in practice. So
it'd be my pleasure. And thanks for everything you guys do at The Reload. I read it all the time, and more people should, because it's a place to get a lot. Sometimes I find things out first by reading your stuff. Thank you.
I appreciate that. It's a great endorsement. Thank you so much. And we will head over to our news segment now.
Thank you.
All right, ladies and gentlemen, it's time for the weekly news update. I'm contributing writer Jake Fogelman, joined as always by the Reload founder, Stephen Gutowski. How are you this week, Steve?
I'm doing well. How are you, Jake?
I'm doing all right. You had an interesting story this week that we're going to be talking about here. The state of New York, in a court filing, made an interesting argument for why its new post-Bruen concealed carry law should be upheld. If you want to tell us a little bit more about what they put in that court filing.
Yeah, so this relates to New York's good moral character clause, which allows officials to deny applicants based on subjective concerns about their moral character, right? You could perhaps see why that might be problematic to some people, but it's being challenged in court by Gun Owners of America is the main gun group behind this one. But yeah, New York filed a brief which defended this clause by citing historical bans on the ownership of guns by Native Americans and Catholics. They said that was relevantly similar to their good moral character clause. And the reasoning they used is that those bans were against people considered to be dangerous or disloyal to either the United States or England, because these laws a lot of them are actually from the 17th century, not from the founding era, although obviously some of the Native American bans did continue on into the early days of the American Republic. But the idea is that these were supposed to be examples of general bans against dangerous people owning guns, and so therefore New York can subjectively ban people from carrying guns based on, or I suppose they also have pistol purchase permits there,
Right,
from owning them if they're considered to be suspect or dangerous, potentially dangerous. And so, obviously that caused a bit of a stir because, well, New York is saying that their modern regulation is relevantly similar to these racist, bigoted gun bans of the past. And that didn't impress a lot of people. And so it'll be interesting to see what the court does with this argument.
No, I think that's right. And just for context, for people who I'm sure many of our listeners do know, but they didn't just pull this out of nowhere. This is the court attempting to use the new Bruen test that was established by the Supreme Court, which said that no longer can you justify gun regulations on an interest balancing scale, where is it working towards the goal of improving public safety. The court said, no, you can't do that. You have to decide, does the law implicate the text of the Second Amendment? And if it does, is there a sufficient historical analog to this law that would allow us to uphold it under the Second Amendment? So this is them, as you said, trying to find a relevant historical analog. But as you also pointed out, I'm not sure that drawing on laws that are explicitly racist is going to buy them much favor with the courts.
Yeah, I did a members piece that looked at or that asked a bunch of experts what they thought about this. And I asked, four or five different constitutional law experts from different sides of the aisle. We had Robert Leiter from George Mason University, Andrew Winkler from UCLA, Eric Rubin from SMU, Andrew Willinger from Duke, and Josh Blackman from Southern Texas, who also, basically they didn't think this was going to actually work in court. Like you said, they noted that this is an outgrowth of Bruen. This is New York trying to respond to Bruen, trying to come up with historical analogs for their laws. And I think as Leiter put it, they just don't have many to point to. And so they're using this, this argument about these racist and bigoted gun bans being an example of depriving dangerous people their gun rights. That argument has been around. Even Justice Amy Coney Barrett made this argument or at least cited it in Cantor, which was about nonviolent felons. She used it to try and say that that nonviolent felons, shouldn't be prohibited from owning guns because only dangerous people should. And she used this example to explain why dangerous people considered to be dangerous were that's a historical tradition of denying them gun rights. But I mean, it's not a very solid foundation.
Right.
If that's your argument, at least from my perspective. But taking that argument and then trying to apply it to this subjective denial of rights to anyone basically considered for any reason to be, or for many different reasons to be a threat. I mean, Leiter talks about New York City at one point was trying to deny permits to people who had too many speeding tickets, too many traffic violations. And so really not, he doesn't think that it's a close connection. And none of these experts seem to think that this was going to be a winning argument in court, although they did think that perhaps this law or some other subjective discretionary standard for permit issuing might survive based on other factors like, there are some of these discretionary rules in some shall issue states that, go back a little bit further and the court didn't find issue with in Bruen directly, although obviously the court wasn't specifically deciding that issue in Bruen. So it's hard. I don't know how much the court is going to allow discretionary subjective standards to remain in the gun carry permit application process, because they seem pretty adamant that they don't want this right can't be limited by subjective judgments.
Yeah, no, and that's what I think is interesting about this particular argument, because as you pointed out, there are other states with similar clauses, some of them almost identical to this good moral character requirement. I know Massachusetts kept theirs in their carry permit law. I believe California still has one in their relevant statute, and they're also working on their own sort of omnibus restricted post-Bruen carry bill. And you can believe that gun rights advocates are going to challenge those laws as well at some point. And
sure,
it'll be interesting to see if governments in those states take up this same line of argument when they're trying to look for historical analogs to uphold that, because they're going to fight to defend those requirements.
I think that if your only historical analog are these explicitly racist or bigoted gun bans, then maybe your law is not that great to begin with. I don't know. Like, you'd think you could find other. Now, to be fair, New York did pull out a couple of other arguments. That's what makes this even more bizarre to me personally. I'm not a constitutional law expert like some of these people that we talked to for that members piece, but New York pulled out a couple of other perhaps also perilous arguments, but they pointed to some militia laws that let people be disarmed if they're allowed, officials to disarm people if they suspected the person was disloyal to the United States, or they specifically cited Shays Rebellion and how people who participated in Shays Rebellion, which again was an active rebellion against the government, they weren't allowed to have their arms. They had their firearms taken away for 3 years until they swore an oath of allegiance. And a lot of these things resulted in like swearing an oath of allegiance or paying a very small fine, which is also obviously pretty different from what New York's law does, which is just deny people their rights indefinitely without any recourse. But either way, like, they found some other analog they could at least point to, and I don't know why they didn't just go with that one. Probably, I guess, because Barrett had mentioned this particular line of reasoning at one point in her dissent. But boy, it's just not a super compelling one, I don't think.
No, yeah, and there's no reading between the lines with this. These are as you pointed out, these are laws that are overtly racist. They in explicit terms identify disfavored ethnic groups to disarm. So it's not like one of these things where it's like, oh, it had disproportionate effects on certain groups. No, these were overtly targeted at certain groups. So it's, yeah, as you said, it's kind of a bold strategy to cite that favorably to uphold your law.
And, a lot these modern regulations that New York has in place, including the good moral character clause, which, again, it's not hard to see how that can be used by a bigoted official to discriminate against people. And frankly, as we saw with some of the briefs in Bruen from public defenders in New York, these laws are generally used in the modern day in a manner that's fairly discriminatory. It's applied mostly to young black men. They're the people who are being prosecuted under these laws for the most part, much more disproportionately compared to their population, right? Their percentage of the population. And so while these modern laws aren't explicitly about barring black people or Native Americans or Catholics from owning guns, they do have discriminatory effects, or at least effects that are applied disproportionately to certain racial groups. So, it's an especially bad look to go and take a law that has been criticized for its disparate impacts on different minority groups, and then justify its existence by pointing to explicitly racist laws from the past. Yeah,
that's a good point.
It's pretty remarkable. It'd be kind of like if you tried to justify some of the, like a voter ID law by pointing to, poll taxes and, the grandfather clauses and things of that nature from the past as well. Like, even though the modern law, if you're going to do that, people are going to be a lot more suspicious about your modern iteration of that voting restriction. So, it's fairly remarkable to see them do this. I think, you've heard forever, if you've ever been on the internet and interacted with a gun rights advocate, you've heard that gun laws are racist, right? That in fact, the argument you'll commonly hear is that all gun laws are racist. And this formulation, now you have New York saying this in court. Yeah, our laws are similar to these racist laws from the past. And it's not something I expected them to ever do. Even with Bruen, I understand, the experts kept saying, well, this is because of Bruen, because Bruen makes you look for historical analogs. Well, I get that, but you don't have to cite the racist ones, the openly, extremely explicitly racist ones. You could, like I said, they found some other things to point to. I don't know that they're better arguments, but they at least don't have you saying, yeah, our law's like this racist law. So,
it'll be interesting to see how long-lived this line of argument goes in these future court cases, because that's a tough look.
Yeah, I mean, even the left-leaning experts didn't think this was going to actually catch on and be effective in court. And regardless of what Barrett might have written in a dissent at one point, I don't see the court adopting this line of reasoning anytime soon. It's also just like they want to take this thing and then apply it extremely broadly anyway. Like, their lesson that we're supposed to take from these laws is that anybody the government deems dangerous for basically any reason, in this case, because the people passing these laws were bigoted against Native Americans and Catholics. Therefore the government can declare anybody suspect or dangerous without them having to actually commit any sort of crime, right? Which is something I think we've rejected quite a long time ago in this country, at least the explicit version of it, right? So we'll see what happens with this. We'll continue to follow this case. I'm still amazed they even went this route to begin with, but I don't think it's going to make it very far on that defense. It may on other defenses, as the experts talked about in the piece, these discretionary laws aren't necessarily a slam dunk to get tossed out. But we'll continue to follow that. But in the meantime, I actually have one of my favorite segments coming up. We have a member segment, so we're going to head over to that now. All right, we've got another one of my favorite segments this week, the member segment. We have Douglas Jefferson from, he's actually the vice president of the National African American Gun Association, but he's also a Reload member. Welcome to the show, Douglas.
Thanks for having me, Stephen.
How you been?
Can't complain. It's been pretty busy on the side of NAGA, just with the Supreme Court ruling, the new legislation that's gone out, and just the general conditions, how things are out in the world. We've had a lot of movement as far as membership and a lot of interest and, kind of helping us to do some new things and get us focused on where we need to be to get that information out to folks that are interested in owning firearms that never had interest before now.
Yeah, and we met at SHOT Show. I saw you guys had a booth there, and you actually launched a new magazine too during
Correct.
SHOT Show this year, back in January. So you guys are
Correct.
doing a lot of stuff, right?
Yeah. So Caliber magazine that you referred to, that was a really big accomplishment for us. We put that together rather quickly, I think, from inception of when the idea came about to, hey, let's do a magazine, to actually getting it, printed and put out, newsstand ready, was a little bit over 90 days. So we did that really, really quickly, but it turned out amazing. I couldn't have asked for a better team that put that together. And, we've had really great reception from not just our members, but from just anyone that we've encountered and showed that magazine to. They've been really excited to see that. So I think it's a testament to all the hard work on the folks in the organization and the dedication of our members that, allowed us to be in a position to do that.
Yeah. I mean, it's certainly an interesting, unique offering, something that haven't really seen before in the gun world, in terms of a magazine dedicated to African American gun ownership from a cultural perspective, right? And I think it's really fascinating. I really enjoyed the first edition. And how often are you guys going to put that out?
So we put it out on a quarterly basis. So
Okay.
4 issues per year. We're about to release our 3rd issue, should be coming out in just a couple of weeks. So, and then we'll be, working on finishing up that 4th issue to round out the year. Wonderful.
But you mentioned, a lot of new people getting into firearms, a lot of African Americans doing the same, of course, becoming first-time gun owners the last couple of years. But I'm interested in your personal story, since it's the member segment. So,
Sure.
How did you get into firearms?
So I guess as far as gun owners, I got into firearms kind of late in life. The traditional story here is, you grew up, shooting with a relative or a family friend. Didn't have any of that. I didn't get into firearms until my mid-20s. And it was funny how it happened. So at the time, I was working with the Georgia Department of Defense. I'm a Georgia resident. So lifelong, Georgia native, love the state. And so in my position I was working in, worked with a lot of National Guard and Reserve unit members. So, of course, it's a lot of guys there. We talk about everything, talk about sports, talk about women, talk about, video games, talk about, just all the typical guy stuff. And conversation comes up about guns. And, I'm just kind of sitting back, listening and observing. And one day, one of the troops asked me, it's like, well, hey, Doug, why don't you ever say anything when we're talking about guns? I said, well, I don't really have much to contribute because I don't really have much experience with them. And he's like, okay. He's like, well, you live in Georgia, right? And it's like, yeah. He's like, you've grown up here. Yeah. And he's like, well, you can go out and shoot a gun. It's like, yeah. It's like, so why haven't you? And I was like, I didn't have a good answer. It had never really crossed my mind. So the very next week, when I had some time off, after I'd, done my laundry and done my grocery shopping or whatever, I went to the gun range, went through their safety class, because I told them, like, hey, I've never shot a gun before. I want to try it. They got me set up with it was a Glock 17, gave me a box of rounds, gave me the gun, put me in lane, explained all the safety features and how to, the basic fundamentals of marksmanship. And I took my first shots and I was like, God, this is pretty cool. So it's kind of jumped into it from there. And I kind of jumped into it with both feet because my first gun purchase after that was actually not a Glock, but it was an AR-15. Yeah, so I started shooting that and, started taking a bunch of classes, got really hooked on it. And but with anything that I do, I like to know all the history and everything about it. So I started looking into, well, what's the history when it comes to African Americans and guns? Because, typical media representations, gun owners are, typically not African Americans. And where you do have African Americans talking about guns, it's usually negative, be it, with a bad guy in the movie, the criminal, the crook, or even in the news media, it's usually portraying some type of negativity. Mm-hmm. So I got really drawn into the history of how much gun ownership has been linked to African American people being able to be fully enfranchised citizens in this country. In particular, its link in allowing African Americans to gain and protect voting rights, which is not a story that's really spoken of a lot. So that really intrigued me. And, made me start asking questions in my own family, which I found out, both my parents had grown up shooting. They never really talked about it at all when I was a kid. So I'm like, wait, you did this and you never said anything? And they weren't anti-gun. They're just really gun agnostic. They were like, hey, guns are a thing. They exist. Good people have them. Bad people have them. It just depends on who's using them because it's just a tool. So that was my understanding of them growing up. And of course, I knew my grandfather. I knew that he owned firearms because, he lived on a farm. And even now, he's he'll be 94 this year. Wow. He still sleeps with a shotgun by his bed. So lifelong gun owner with him. And, he taught my mom to shoot. On my dad's side, he learned to shoot from, some of his relatives, grandfather and such. So the history there, but, this wasn't talked about. So now that I'm into this space and talking about firearms, we have, a lot of interesting conversations nowadays because those kind of memories and things they never really thought about, they'll come up when I have conversations about whatever I'm doing with the organization. So that's been really cool.
Oh, nice. Yeah. So you have a new way of connecting there. Actually that story is pretty similar to how I got into firearms because I didn't grow up shooting either. I didn't shoot my first gun until after college, actually, when it was an office fun day where my first job out of college. So, it was a sort of late bloomer too. I think a lot of people assume when you're, involved in this space, as we are, that you've just been shooting your whole life, and it's not necessarily the case. Right. But that's really fascinating. Obviously, your journey into gun ownership, or I guess down the snowball of gun ownership after the first purchase, involved that unique African-American history of gun ownership in the United States. And now, of course, you're vice president at the largest African-American gun owners association in the country. How did you, move from that point of researching the history that you just spoke about into, political activism in the modern day?
So my involvement with NAGA started in 2016. So the organization had only been around a year. It was founded in 2015, in February 2015, in honor of Black History Month by Philip Smith, the president and founder of the organization. So I had finished up a range session at a local range that I was at. It was actually at a new range I had never been to before. A friend of mine had suggested that I checked out. So I went to this range, did my regular shooting session I was doing at the time on the weekend. So I come out and run into a gentleman. He introduces himself and we just start to chat. And then, as gun people, somebody wants to go up and talk. Think, okay, we're going to talk about gun stuff. And, it's the South too. So it's, real friendly environment. So he was started telling me about his organization, gave me his card, asked me to check it out. So I said, all right, I will. And I'd already started a little bit of reading about it. So that it intrigued me. So I go home, check the website, liked what I saw, went to see when the next meeting was, and showed up at the next meeting, which was a couple of weeks out from the day that I met Phil. So from that point, just started working in the local chapter, going to the events, then started helping to plan some of the activities, eventually moved into running the social media for the entire organization, which was only the one chapter when I first joined, and Phil and I worked to kind of expand that and grow it out. So say probably around into 2017, First part of 2018 was when I moved into the position of vice president of the organization. So I've been working very closely with Phil and the rest of the team ever since to kind of grow the organization, its influence,
and how many
on the culture.
How many chapters are you guys up to now?
We are about 120 chapters nationwide. We're in over 30 states of the U.S., about 45,000 members nationwide.
Wow. Yeah, you guys have grown really fast.
Yeah.
In a short period of time. It's amazing. This is probably straightforward then how you became aware of the Reload, but can you give us a little bit of background on why you decided to become a member?
Sure. So one of the things that, as the vice president of the organization, of a gun organization, I've, got to keep up with a lot of what's going on in the news related to firearms. And I was always looking for new places where I could get that information and get really good analysis of the situations. And you can kind of piece it together from, you're really super pro-gun, shall not be infringed, yelled from the rooftop. And then you've got the, super anti-gun, these things are dangerous. The world would be so much better and there would be no deaths if, guns just got rid of. Right. So you get those two and you kind of try to parse what's the truth between the two of them. Right. And so I found a couple of sources that were really good. One of them was Open Source Defense. And I actually met one of the writers who he's local here in Georgia. And so him and we struck up a friendship and we, communicate on a fairly regular basis. And I started asking him like, hey, what are some of the sources he goes to and whatnot? And he happened to mention the Reload. He said, hey, I know this guy, Steven. He's done a lot of writing on Second Amendment issues, but he has really good sober analysis of it. I think it's something right up your alley. You should check it out. So I said, all right, cool. So I go to check it out. I liked what I read and I was like, oh yeah, this is great. I definitely need to keep my eye on this and make sure that I'm getting this information on a regular, because I don't think that there's any other place that covers any gun culture, gun rights, any gun legislation, especially the way that you do, and really bringing forth that analysis of, really looking at, hey, what's the good part and what's the bad part of it? Because, I don't think you make it a secret that you are a supporter of Second Amendment rights, but you don't let that color your reporting. I always feel like I'm getting a good, honest, balanced analysis of whatever's going on. Because I see you're just as quick to identify, some of the negative, portions of segments or ideas that come out of gun culture, which, and as a gun owner, I have to be honest, there are some negative pieces. It just as much as you're there to highlight the positives. And then the same way that you do on the side of folks that are pushing, anti-gun legislation or anti-gun ideas. So I just really appreciate that balanced analysis, which can be, just really on any topic, especially controversial topics in this day and age, can be really, really hard to find. Yeah.
I think you really hit the core of what I'm trying to do. So I'm really glad to hear that you feel that way about it. But yeah, we try to provide as sober and serious, I guess that's the tagline, right, of a look at gun politics in America and try to give people, a realistic idea of what's going on, whether it's something they like or don't like. They just try to be truthful with folks and give the best, especially when it comes to the analysis, give the best view of how this is going to impact things. Not always right either. I think we have a pretty good track record, but when I'm not right, I try to point out, like the Sullivan's ban did not think that was going to pass the House. It did. I don't think it is going to pass the Senate, but we will keep on top of that one as well.
Absolutely.
But yeah, it's just something where I think honesty and straightforwardness is more valuable. There's a lot of great opinion folks out there who are giving valuable intake or insight into what's going on by sticking to their core principles, but there's a lot of people who give really bad insight because they are very rigid and inflexible about even just understanding what's happening. So I'm really glad to hear you say that. I think your group in particular is one of the key groups that's going to be influential for how gun culture is going to be shaped over the next several decades here. I think the rise of minority gun owners and female gun owners and gun owners who are younger and live in more suburban areas than rural areas are going to be a huge part of how guns in America shake out over the next 20, 30 years. So, and you can already see it in the growth that you just described
Absolutely.
of your group. And so, we're definitely going to keep in contact with you guys and follow what you're doing and do our best to report on it fairly through the future here. But if people are interested in hearing more about NAGA, how can they do that?
Sure. So you can check out our website, www.naaga.co. That's where you can join. That's where you can find out more information about, who we are. If you're interested, find out, where the chapter closest to you is. We're also on your major social media under Official NAGA and NAGA National on Facebook, on Instagram, and on YouTube. Particularly on YouTube, we started a panel series where we're talking about different gun rights issues from the perspective of the African American experience. We've had 2 sessions already. The first one, we were talking about the phenomenon of mass shootings. And the second one we had most recently about a week and a half ago, we were talking about the impacts of the Bruen decision and the new bipartisan gun bill that was passed just a little bit ago, I guess about a month back, just the day after the Bruen decision, in fact. So we're really moving towards having conversations about what the impact of these laws, these legislation is on the African American community. Because often just find that, there's no one that's really speaking of it through that lens. So we're going to be the folks that are going to have that conversation. And, whether you ultimately decide that you agree with our take or not, we just want to make sure that people have, proper contextualized, nuanced info to make that decision at the end of the day.
Absolutely. Well, thank you so much for joining us. And for those of you listening who want to be a member just like Douglas, you can head over to thereload.com and check out our membership options today. You'll get exclusive access to hundreds of pieces of news and analysis that you can't get anywhere else. You also get this podcast a day early, a day before everyone else, and you'll have the opportunity, of course, to appear on the show if you would like. And so I think it's a pretty good deal, personally. But
absolutely, well worth the money.
There you
Never
go.
regretted it.
There's an endorsement for you. But we'll see you again next week.